Hello. In this clip from our Justia webinar, AI, Legal Developments, Risks, and Benefits, Sarah Anderson answers some of the audience's questions while sharing her final thoughts about the unintended consequences of using AI. If you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Like I hinted on the privacy thing, this is a huge one. If your business does any kind of, medical, and I will say, especially if you're a lawyer, if you guys do any kind of medical malpractice cases or a tort case where you deal with a lot of medical records, you could be considered a business associate if your practice requires you to regularly interact with protected health information, especially in an electronic format. You really want to make sure that you consider how you use these AI tools, because as the Journal of American Medicine only pointed out recently, and I will say this is about a year ago, entering information into AI chatbots is a HIPAA violation, and business associates can be liable for HIPAA violations through their covered entity. So something to think about, because they do not have any privacy filters on ChatGPT that I'm aware of that protect HIPAA violation. And if you know anything about how to anonymize data under HIPAA, you have to remove about 18 characteristics, which basically means there was a person and they saw a doctor. So I would block this from your websites. Let's talk about unintended consequences with the last few minutes of our time together, right? I'm going to speed through this one because it's pretty simple, but this is similar to the Illinois law we saw. And I will tell you, this case actually just settled last month, perhaps. Or earlier this month. They received a notice of settlement. I checked it earlier today. So this is a case where a gentleman was interviewing for a job with CVS. CVS videotaped the interview and then uploaded the videotape to an entity called HireView, and HireView would analyze the video to determine the veracity of the subject's answers. Now, unlike Illinois, Massachusetts does not have a law that says if you're going to do that, you have to notify the person before you do that, right? They don't have a law specific to AI, but Massachusetts does have a use of lie detection statute. And it basically defined a lie detector test, meaning something that would be subject to the statute, as any device, instrument, or mechanism, the results of which are used to interpret, deception, right? So even though CVS videotaping the interview was not doing that, and even though there was no AI law in Massachusetts prohibiting them to do that without the subject's consent, the anti-lie detector statute, right, found that since it said any mechanism, that technically was a lie detector statute. And so the AI tool violated the anti-lie detector laws. And that was a huge class action. They did not survive the motion CVS was not successful with their motion to dismiss. And as I said, they recently settled, I really want to say on August 2nd. So super recently, I checked this morning. So that would have been a huge trial had it gone forward. I think CVS, because this was going to be a class action. Another one is nuanced communications. So this is in the Northern District of California. This case, don't think has settled. In fact, I think I saw a case management order this morning when I was looking at it. But essentially what happened is Turner called Chase Bank and to inquire about something. And she was under the impression that her conversations with her bank would be confidential, because usually they are. Well, what she didn't know is Chase Bank had hired Nuance Communications to take a voice print of each of their callers so that they could identify fraud on those accounts in the future. In other words, if I call my bank and I'm saying, hey, this is Sarah, they're like, okay, hey, Sarah, nice to see you. And they compare it against my previous voice print and they're like, okay, she's good to go. That is in fact Sarah. It's not someone pretending to be Sarah on the phone, right? And they sued Chase Bank, JP Morgan, which owned Chase, and they also sued Nuance. Well, they sued Nuance under the California Invasion of Privacy Act, which says there can be liability on anyone who eavesdrops on confidential conversations or creates voice prints on a person to determine the truth or falsity of the information. Well, Nuance wanted to say that, hey, we're not a real third party. We were just acting as an agent of Turner, right? We were acting as an agent of Chase when Turner, ended up interacting with our system. It was not individually as a third party, right? Whereas Turner, to get liability against Nuance, had to argue that they were in fact a third party intercepting conversations with Chase, even if they were doing it, sort of at Chase's will. And what they said was, the court said, yes, they were acting as a third party, which means they could be sued because they were feeding all of those voice prints that they were collecting from Chase into their overall big AI voice engine, which was being used to modernize and train new AI tools that they were developing. And it was also being used for other companies. So again, if your client is Nuance, you want to be aware of that you could be brought up on these claims, even if, right, you're doing this as an agent of JP Morgan Chase. So this case, motion to dismiss was denied, and there is a case management order currently if you want to look it up on Pacer. Carpenter versus McDonald's. This has since settled. It settled last summer. This was also a voice case. Illinois has a Biometric Information Privacy Act, which gets tons of damages. They have statutory penalties as well. And this was a case where McDonald's decided they were going to input voice identification features into their drive-thru. So instead of having to talk through like a very grainy squawk box, right, and no one can hear you and you can't hear them and your order gets messed up, they're going to have something where they register your order based on just voice recognition using AI tools. Well, what they didn't understand is that while Illinois did not have a rule against that, against using AI for this specific purpose, they did have a biometric information privacy law, and voice prints are considered biometric information because it's specific to a person, right? And then they were using that over and over again to further refine their existing tool, right? So they ended up taking, the tool that they were using for McDonald's, refining their own tool, storing that, using it to refine other tools. And since they didn't get the requisite level of consent required to collect biometric information, which there's a very detailed list in the statute of how you have to get consent and what you have to do with the data, they failed to adhere to the Biometric Information Privacy Law, which carries a minimum statutory penalty, I think, of up to $7,500. It's either $5,000 or $7,500, depending on how nefarious the conduct was. But I think the floor is $2,500. And so they ended up settling the suit because it would have been, think how many people go through McDonald's. So again, not an AI law, but another law that caught AI up in its sort of web. This one is my favorite case to talk about, and if any of the attorneys involved in this case are on this call, I'm so sorry. This is another case of AI gone wrong, except it involves moronic attorneys, right? So Mata was a airline passenger on Avianca Airlines, and he's sitting in the aisle seat, and he gets hit in the back of the heel with the beverage truck, right? And he sues just in a, knee injury, in state court. He gets removed to federal court. Well, someone filed a motion, or Avianca filed a motion to dismiss. And instead of writing an opposition brief, using their own individual research or a law clerk or an associate, Mata decided to go to ChatGPT and say, ChatGPT, here is the motion to dismiss, write me an opposition. Well, remember, I told you, ChatGPT is the drunk uncle at a family funeral, right? He is always confident, but seldom correct. ChatGPT will give you an answer, even if an answer doesn't exist. Well, and that's exactly what they did. ChatGPT wrote a brief and fabricated cases and case laws and citations. Well, the court gets the brief, right? And they look at it and go, where are these cases? And the opposing side gets a brief and says, these cases don't exist. Well, the court gives, Mata's attorneys, the option. Hey, look, what's going on here? And they say, don't worry. And the judge says, fine, produce the cases. Well, they go back to ChatGPT and ask ChatGPT to write the cases. Well, like I said, not correct. So ChatGPT comes back with these like absurd cases where the fonts are changing, mid-case, legal theories that don't exist are being cited, other cases that don't exist are being cited. And it would have been super obvious had they read any of these cases that this is completely illogical. Well, they get called on the carpet in front of a federal judge, right? Judge Castle is like Dr. Evil in Austin Powers. He's an evil genius. So rather than like ruining their lives directly, he ruins their careers. So he only fines them $5,000 for lying to the court twice. But he makes them write a letter to their client and all of the judges involved, and I think also the Bar Association, admitting exactly what they did and set them up from being never able to practice in the state of New York again because they just pissed off every judge, and also set their client up for a great malpractice case. So again, just keep this in mind. Don't use ChatGPT, block it. In fact, the Fifth Circuit Court of Appeals, which is where I sit, right, has a draft rule out there that basically requires everyone to say that they didn't use, an AI tool to create their brief and they, checked their own materials and are not relying on somebody else. So like I said, I had key takeaways at the end and I'm really time conscious. So I apologize for speaking so fast. But like I said, I always have a theme and then I have key takeaways, right? My key takeaways here are pretty self-explanatory, but the biggest ones I want to know, right, is where's the source of the data, right? Are they protecting that data from intrusion? How is the device going to be used? Is there any way it would fall under the purview of any regulatory agency? And again, I've only really seen DHHS go under that. Another one would be the FTC under Section 5, because there's basically like a deception rule. However, if it's specific to an area, it would be worth checking that agency's Code of Federal section in the Code of Federal Regulations, right? Prohibit all your employees from using ChatGPT. Clearly define how you're going to use this AI tool. Don't just be like, oh yeah, use it for anything, because then you'll misuse the tool and it could be exceeding the scope of what it was intended to and give you false results. And probably the most important one is always get consent. When in doubt of using an AI tool and you're not sure what trap you're going to fall into, just get written consent from anyone who's going to be subject to that tool or have their information input into that tool. So that is all for me. I'm going to stop share and ask Nina to come back in and see if anyone has any questions. Thank you so much, Nina. I hope I did okay on time for you today.
Thank you, Sarah. Yeah, you're great. And now we can move on to audience questions. So if you have a question for Sarah, please feel free to submit it through that Q&A button in the control panel at the bottom of the screen. Sarah, it looks like we already have a few questions.
Yeah, I'm going to just go in order of time, if that's okay.
Yeah, absolutely. Go ahead.
Okay. So, Mr. Roberts, is it safe to use AI programs without any risk of them installing a virus on my computer? The answer is yes, but no. It depends, which is the classic lawyer answer. So, if you are what is called an administrator in a computer, meaning that you can download anything and you don't need permission from an IT department or someone else, usually if you try to download something and you're in a larger office, it'll pop up with a box that says like you need administrative permission, right? I would always ask somebody in tech what they know about the tool, because usually, there's different reports online about that tool before you download it. It's another thing to consider is if you're using solid endpoint detection and response software, if you are downloading that tool, it should alert you if there is anything malicious that it identifies when it's downloading. So I'm a CrowdStrike user, and yes, I'm taking a beating in the market right now because I'm also an investor. But I open whenever I'm going to download something, because I am the administrator on my machine. I go ahead and open up my CrowdStrike portal, and I just, as it's downloading, because it'll immediately notify me before it allows, and it'll stop it. And I'll have the ability to stop it before it comes down. So I would make sure that you have good endpoint detection and response software, and that you do a little research on the tool, because a lot of times threat boards will catch this stuff really fast. People aren't hiding this information out there before you download it. The next one that we have at 12 or at 102 is when advising clients on AI implementation, how can lawyers help develop compliant and ethical policies? This is such a great question. So the first thing I would do is kind of like my answer to the previous question is I would make sure they've done their research on the application before they implement it. I would also make sure that any of their employees cannot just download, random programs, because this has the ability to move. I would make sure that all of their employees are local users, meaning they can't really download anything without permission, so that they control what comes into their environment, especially if they want to use artificial intelligence, right? So that would be the first one. The other way that I would monitor this, again, with my employees, is I would block the, open source artificial intelligence tools like ChatGPT, like I said in my presentation. And then if they want to request additional tools, put it in the employment policy that they're not authorized, just in case they get around any of those procedures, or there's a loophole, that they're not allowed to download any third-party programs without explicit consent, from, the system administrator, which will usually be your IT department, or if they outsource that, their managed service provider, and make sure that it's downloaded in another environment first, so that they can test it. So that would be my, best 30-second answer. Let's see, who is next? What direction are AI laws leaning, especially in terms of data privacy, intellectual property, and liability? Oh, this is such a good one. So, there's actually a case against GitHub, which is like an online software source code sharing platform. And so the answer is, I don't know yet. Except to say that a lot of software programs will borrow from each other and incorporate each other's code into building their programs. So it really comes down to how much code was it? Did they protect that code? Did they offer it for free on the internet? Right? So it's all going to be very specific, but there is a great case. And of course, the name is escaping me now, but it did involve GitHub. And I think it was somewhere in Federal District Courts of California, where the court did a very thorough analysis, but it was in fact fact specific. So that would be the best way to answer that question, is to search for that case. And I'm sorry I don't have the site on me, but I'm going to add that to my next presentation. So thank you for that question. Next one. How do you think we can improve the AI training programs that are being used in the public sector? Is that in the work? I don't know. I really don't know. I don't think those are going to be coming anytime soon. I think you're going to have to wait. The best option for AI training programs, Microsoft is doing a better job through their O365 platforms of creating different employee training programs that usually involve around like anti-phishing campaigns. Would be to check back with Microsoft and see if they're offering any of those through the O365 platform, because that's probably going to be the first place that you see it. All right. What key clauses should be included in contracts involving AI to address data ownership, IP rights, or liability for system errors? So in all of my contracts that I do for managed service providers, software developers, whatever, the first thing I say is that this is not a work for hire contract, meaning anything I develop, especially if my client is writing code, does not immediately belong to you. right? It's not a work for hire agreement. This is an agreement where I'm developing something and I'm giving you I'm giving you either a perpetual or non-perpetual, non-exclusive, non-transferable license to use whatever. And so I just keep it very simple and tighten those. If it is something where you're going to be moving into patent and copyright, I make sure that my clients are always the ones responsible for that so that no one can say, well, we did it for you, so now we own a portion of it. So I always make sure, and I put a prohibition of them applying for any type of statutory protection for the tool, unless that is part of the agreement, right? And if it is part of the agreement where they're paying you for it, I always insist on a worldwide, non-exclusive, perpetual, transferable license to that same thing. So essentially the exact opposite of what I would normally put if I was in the opposite position. So, and then liability for system errors, you disclaim all of that. I do a very, very hefty disclaimer in everything because this is not this is kind of like medicine where they can't control how the human body is always going to react. That's why there's all these super rare diseases, right? This is the same situation. I always say in every vendor agreement, no system can be 100% secure. A lot of this is beta testing. And if it is a new product, say it's a beta test. So always add that extra language to make sure it's very clear to the person you're working with, that anything could happen and you're just doing your best and you're offering them commercially reasonable standards because that's really the only recognized standard based on the sophistication of both parties. Next one. Do you think there will be a lot more legislation addressing AI? Is more likely that current laws will be interpreted with AI in mind? Both. So the nice thing is, kind of like we saw with the California Consumer Privacy Protection Act, or I think it's Consumer Privacy Rights Act now. Sometimes they talk about as one and the same, and sometimes they separate them. I think the Fed is going to follow the states or just leave it alone and see what the states do because they're just really not in a position to do this now. And with Colorado and Utah developing their own programs, they're going to kind of see how that goes. And like I said, California released their drafts last December. They released their drafts. And then in March of 2024, they announced that they were undergoing further review. So I would expect to see movement from California on this. The EU has also put out their own AI guides, but a lot of their stuff is just like really absurd. So I wouldn't expect that to go through, but I would watch the states that are already moving on it. And I would expect that to set the pattern because anything the Fed does, they're going to watch and see what happened at the state level, especially, in California, which is like the 5th biggest GDP in the world, just in and of itself. So that's where I would focus my attention. All right, last one. I uploaded 6 transcripts of deposition and asked AI program to give all instances in which I've seen these things, in which the deponent mentioned X. I got a response, page and line. My transcripts are floating around somewhere on the web. It depends what the, your terms of use of the program say and what it's, the program says it's going to do with that data. But it's very possible that those transcripts are floating around somewhere. The good news is if those transcripts are publicly filed, then it doesn't matter, right? Because it's already out there and you haven't done anything that's already not out there on the web. Those programs are super, super useful in the sense that they can help kind of cut down on materials. But again, it's just one of these things where if you're using a web-based tool as opposed to like a localized installation that doesn't feed back to the web, that's really where you got to kind of take a look and see what is the possibility of that information getting out. Any other questions, Nita?
I think that's everything. Thank you so much for answering our audience questions, giving that additional insight. And thank you all so much for submitting your questions. I do want to go ahead and thank you all so much for joining us for another Justia webinar. Thanks for watching. We hope you enjoyed this video. And if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.